Greetings and welcome to another journey through the esoteric realm of equity jurisprudence. Where equity sees done that which ought to be done. I'm Equity Ed, and I would like to welcome you to another enlightening episode of our ongoing series. Today, we embark on a journey through time as we explore the evolution and future of equity jurisprudence. This episode will take you from the historical origins of equity, through its development and refinement, to the role it plays in modern legal systems, and finally, to speculation on its future in an ever-changing world. By the end of this discussion, you'll have a deeper appreciation of how equity has shaped the law and continues to adapt to meet the demands of justice. Segment 1. The historical evolution of equity. The story of equity begins in medieval England, a time when the rigidity of common law often resulted in injustice. The common law courts, with their strict procedures and limited remedies, were unable to address the needs of many litigants who sought relief. It was in this environment that equity emerged as a necessary complement to the common law, providing justice where the law fell short. The origins of equity. Equity's origins can be traced back to the 12th century, during the reign of Henry II, when the English legal system was being formalized. As common law developed, it became increasingly clear that its rigidity and adherence to precedent often led to unjust outcomes. Litigants who could not find relief in the common law courts petitioned the king, seeking justice based on principles of fairness and morality rather than legal technicalities. These petitions were referred to the Lord Chancellor, the king's chief minister, who held the authority to grant relief based on principles of equity, meaning fairness or justice. The Lord Chancellor, operating from the Court of Chancery, developed a body of principles and remedies distinct from those of the common law. These principles formed the foundation of what we now recognize as equity jurisprudence. The development of the Court of Chancery. The Court of Chancery, formally established in the 15th century, became the primary institution for administering equity. It operated alongside the common law courts, offering remedies that were not available at law, such as injunctions, specific performance, and the enforcement of trusts. The Court of Chancery's jurisdiction grew steadily as more litigants sought equitable relief, leading to the development of a distinct body of equitable principles and maxims. One of the most significant contributions of the Court of Chancery was the recognition and enforcement of trusts. A trust is an arrangement where one party, the trustee, holds property for the benefit of another, the beneficiary. While the common law did not recognize trusts, viewing them as legal anomalies, the Court of Chancery upheld them based on equitable principles. This innovation allowed individuals to manage and protect their assets in ways that were not possible under common law, particularly in the context of family and charitable arrangements. The maxims of equity. Over time, the Lord Chancellors developed a set of maxims that guided the application of equity. These maxims reflect the underlying principles of fairness and justice that are central to equity jurisprudence. Some of the most important maxims include: equity regards as done that which ought to be done. This maxim allows equity to treat obligations as if they have already been fulfilled, particularly in cases involving contracts or trusts. Equity follows the law. While equity provides remedies where the law is insufficient, it does not override the law. Instead, it complements the law by filling in gaps and addressing injustices. He who seeks equity must do equity. A party seeking equitable relief must act fairly and justly in their own conduct. He who comes into equity must come with clean hands. A litigant must not be guilty of wrongdoing or bad faith if they wish to obtain equitable relief. Equity will not suffer a wrong to be without a remedy. This maxim embodies the principle that where there is a wrong, equity will provide a remedy if one does not exist at law. These maxims continue to guide the application of equity in modern legal systems, reflecting the enduring importance of fairness and justice in the administration of law. Segment 2. Equity in the modern legal system. As we move from history to the present, it is essential to understand how equity has been integrated into modern legal systems. While the Court of Chancery and the common law courts originally operated separately, a series of reforms in the 19th century led to their merger, fundamentally changing the administration of justice. The Judicature Acts of 1873 to 1875. The most significant development in the evolution of equity jurisprudence was the passage of the Judicature Acts of 1873 to 1875 in England. These acts merged the common law courts and the Court of Chancery into a unified court system, known as the Supreme Court of Judicature. The merger allowed both legal and equitable principles to be administered by the same courts, effectively ending the procedural and jurisdictional divide between law and equity. Under the new system, judges were empowered to apply both legal and equitable remedies in the same case, ensuring that justice could be administered more efficiently and fairly. The Judicature Acts also established the principle that, in cases of conflict between law and equity, equitable principles would prevail. This principle ensured that the flexibility and fairness of equity would continue to influence the development of the law. The merger of law and equity had profound implications for the legal system. It allowed for a more holistic approach to justice, where courts could consider both legal rights and equitable considerations in their decisions. This integration of equity into the broader legal system remains a cornerstone of modern jurisprudence. The role of equity in modern courts today. Equity is an integral part of the legal system in many jurisdictions around the world. While the formal separation between law and equity has been abolished, the principles and remedies of equity continue to play a vital role in the administration of justice. Equitable remedies, such as injunctions, specific performance, and equitable estoppel, are regularly applied in modern courts to address situations where legal remedies are inadequate. For example, injunctions are often used to prevent irreparable harm in cases involving intellectual property, environmental law, and family law. Specific performance is frequently ordered in cases involving unique goods or real estate, where monetary damages would not adequately compensate the injured party. In addition to providing remedies, equity also influences the interpretation and application of legal principles. Courts often rely on equitable doctrines to resolve ambiguities in the law, prevent unjust enrichment, and ensure that the outcomes of legal disputes are fair and just. This influence extends to various areas of law, including contract law, property law, and fiduciary relationships. Equity and statutory law. Another important aspect of equity in the modern legal system is its relationship with statutory law. While statutes provide the framework for many legal rights and obligations, they may not always address every possible scenario or achieve just outcomes in every case. Equity steps in to fill these gaps and ensure that the application of statutory law aligns with principles of fairness and justice. For example, in cases where a statute imposes a strict legal obligation that would result in an unjust outcome, courts may apply equitable principles to temper the harshness of the law. This can include granting relief from forfeiture, providing equitable relief in cases of mistake or misrepresentation, and interpreting statutes in a way that avoids unjust results. Equity also plays a crucial role in the enforcement of statutory rights. In some cases, statutes explicitly provide for equitable remedies, such as the ability to seek an injunction to prevent a breach of statutory duty. In other cases, courts may apply equitable principles to enforce statutory rights, ensuring that the law is applied in a manner consistent with justice and fairness. Segment 3, Comparative Equity. Having explored the historical evolution and modern role of equity, it is now time to turn our attention to how different legal systems approach equity. While equity has its roots in the English legal tradition, its principles and remedies have been adopted and adapted by various legal systems around the world. This segment will examine how equity is treated in common law, civil law, and hybrid legal systems. Equity in common law systems. In common law systems, such as those in the United States, Canada, Australia, and other former British colonies, equity retains a significant role in the administration of justice. These systems have inherited the principles and remedies of equity from English law and continue to apply them alongside common law principles. In the United States, for example, equity is administered by both federal and state courts, which have the authority to grant equitable relief in cases where legal remedies are inadequate. The U.S. legal system also recognizes the principle that equity will prevail in cases of conflict with the law, ensuring that fairness and justice are upheld. One notable feature of equity in the U.S. legal system is the concept of equitable jurisdiction, which allows courts to hear cases that fall within the scope of equitable principles, even in the absence of a legal cause of action. This broad jurisdiction enables courts to address a wide range of disputes, from property rights to contractual obligations, using equitable principles. In Australia and Canada, equity also plays a prominent role in the legal system. Australian courts have developed a robust body of equitable principles, particularly in the areas of fiduciary duties and unconscionable conduct. Canadian courts similarly apply equitable principles to ensure that justice is served, particularly in cases involving trusts, estates, and family law. Equity in civil law systems, which are prevalent in Europe, Latin America, and parts of Asia and Africa, approach equity differently than common law systems. These systems are based on codified legal principles and statutes, with less emphasis on judicial discretion and equitable remedies. In civil law jurisdictions, equity is often incorporated into the legal code, rather than being administered as a separate body of principles. For example, in France, the civil code includes provisions that allow judges to apply principles of fairness and justice when interpreting and applying the law. However, the scope of equitable remedies in civil law systems is generally more limited than in common law systems. Despite these differences, equity still plays a role in civil law systems, particularly in areas such as contract law, property law, and family law. Civil law courts may apply principles of equity to address situations where the strict application of the law would result in an unjust outcome. For example, courts may reduce the obligations of a party in a contract if the terms are deemed to be excessively onerous or unfair. The concept of good faith is also central to equity in civil law systems. Many civil codes require parties to act in good faith in their dealings, and courts may impose equitable remedies to enforce this obligation. For example, a party who acts in bad faith in a contractual relationship may be required to compensate the other party for any harm caused by their conduct. Equity in hybrid legal systems. Some legal systems combine elements of both common law and civil law traditions, resulting in a hybrid approach to equity. These systems often draw on the principles and remedies of equity from the common law tradition while incorporating them into a codified legal framework. One example of a hybrid legal system is South Africa, where both Roman Dutch civil law and English common law influence the legal system. South African courts apply equitable principles in a manner similar to common law systems, granting remedies such as injunctions, specific performance, and equitable estoppel. However, these principles are also integrated into the broader civil law framework, creating a unique blend of legal traditions. Another example is Scotland, where the legal system is based on a mix of civil law and common law principles. Scottish courts apply equitable remedies in cases involving trusts, property rights, and family law, drawing on both Roman law and English equity. The result is a legal system that combines the flexibility of equity with the structure and predictability of civil law. These hybrid systems demonstrate the adaptability of equity and its ability to coexist with different legal traditions. By incorporating equitable principles into their legal frameworks, these systems ensure that justice is administered in a manner that is both fair and consistent with the rule of law. As we look to the future, the question arises, what role will equity play in the evolving landscape of global legal systems? While it is impossible to predict with certainty, several trends suggest that equity will continue to be a vital component of justice in the 21st century and beyond. Equity and technological advancements. One of the most significant challenges facing modern legal systems is the rapid pace of technological change. From artificial intelligence and blockchain to digital currencies and online dispute resolution, technology is transforming the way we interact, do business, and resolve disputes. Equity, with its emphasis on fairness and justice, is well positioned to address the ethical and legal issues arising from these technological advancements. For example, courts may increasingly rely on equitable principles to resolve disputes involving intellectual property, data privacy, and cybersecurity. Equitable remedies, such as injunctions and specific performance, may be essential in cases where traditional legal remedies are inadequate to address the complexities of technology-driven disputes. In addition, the rise of online dispute resolution platforms presents an opportunity for equity to play a more prominent role in resolving disputes outside the traditional court system. These platforms, which use technology to facilitate mediation and arbitration, often incorporate equitable principles to ensure that outcomes are fair and just. As these platforms become more widespread, equity may become an even more integral part of the global justice system. Equity and globalization. Globalization has led to an increase in cross-border disputes, as businesses and individuals engage in transactions and relationships that span multiple jurisdictions. In this interconnected world, equity's flexibility and adaptability make it an essential tool for resolving complex international disputes. One area where equity is likely to play a growing role is in the enforcement of international agreements and treaties. As nations negotiate and implement global agreements on issues such as climate change, human rights, and trade, equitable principles may be necessary to ensure that these agreements are applied fairly and consistently. Courts and international tribunals may rely on equity to interpret and enforce these agreements, particularly in cases where legal frameworks are incomplete or ambiguous. Equity may also play a role in addressing the challenges of global inequality. As the gap between rich and poor continues to widen, courts may increasingly turn to equitable principles to ensure that justice is accessible to all, regardless of their economic status. This could involve the expansion of equitable remedies, such as the imposition of constructive trusts or the granting of equitable relief in cases involving economic exploitation or environmental harm. Equity and social justice. The pursuit of social justice has always been a central concern of equity, and this is likely to remain true in the future. As societies continue to grapple with issues such as discrimination, inequality, and access to justice, equity will be a critical tool for promoting fairness and protecting the rights of marginalized individuals and communities. One area where equity is likely to play a significant role is in the protection of human rights. Courts around the world have increasingly relied on equitable principles to address violations of human rights, particularly in cases where legal remedies are insufficient or unavailable. For example, courts may grant injunctions to prevent the abuse of power by governments or corporations, or impose equitable remedies to ensure that victims of human rights violations receive adequate compensation and support. In addition, equity may be used to address systemic injustices that are deeply embedded in legal and social structures. This could involve the use of equitable principles to challenge discriminatory laws and practices, or to promote greater access to justice for disadvantaged groups. As the demand for social justice grows, equity will continue to be a powerful tool for advancing fairness and equality. Segment 5, Conclusion. As we conclude this exploration of the evolution and future of equity jurisprudence, it is clear that equity has played a vital role in shaping the legal systems of the past and will continue to be a cornerstone of justice in the future. From its origins in the Court of Chancery to its integration into modern legal systems, equity has provided the flexibility and fairness needed to address the complexities of legal disputes and to ensure that justice is done. Looking forward, equity will remain an essential component of global legal systems, particularly as they adapt to the challenges of technological advancements, globalization, and the pursuit of social justice. By continuing to apply and develop equitable principles, courts and legal systems around the world can ensure that the law remains a force for good, protecting the rights of individuals and communities and promoting fairness and justice for all. Thank you for joining me today on this journey through the evolution and future of equity jurisprudence. I hope this discussion has deepened your understanding of the importance of equity in the administration of justice, and inspired you to think about how these principles can be applied in the world today. I look forward to our next episode, where we will continue our exploration of equity and its role in the legal landscape.